Negotiable Instruments Act, Section 76, when presentment unnecessary. Section 76 of the Negotiable Instruments Act, 1881 specifies situations in which presentment for payment is unnecessary, because the law recognizes that formal presentment may sometimes be unreasonable, impossible, or without practical purpose. In such circumstances, the instrument is treated as dishonored even without actual presentment, thereby protecting the holder where non-presentment results from waiver, conduct of the liable party, or other justified reasons. 1. General principle of the section. The section establishes that no presentment for payment is necessary in certain specified situations, and the instrument is deemed to be dishonored on the due date for presentment itself. This means that the holder is not required to perform the formal act of presentment, because liability may still arise where presentment has become unnecessary or futile. 2. Cases where the conduct of the maker, drawee, or acceptor prevents presentment. Clause A covers situations where the person primarily liable makes presentment impossible or impracticable. I. Intentional prevention of presentment. Presentment is unnecessary where the maker, drawee, or acceptor intentionally prevents the holder from presenting the instrument for payment by deliberately obstructing such presentment. 2. Closure of place of business during business hours. Where an instrument payable at the business place of the maker, drawee, or acceptor cannot be presented because the place is closed during business hours, presentment becomes unnecessary and the instrument is treated as dishonored. 3. Absence at specified place of payment. Where an instrument is payable at a specified place and neither the liable party nor any authorized person attends there during usual business hours, presentment is excused because the holder is not required to wait indefinitely. 4. Person cannot be found after due search. If the instrument is not payable at a specified place and the maker, drawee, or acceptor cannot be found after due search, presentment becomes unnecessary because the law requires only reasonable efforts from the holder. 3. Party agrees to pay despite non-presentment. Presentment is unnecessary against any party who has agreed to remain liable notwithstanding non-presentment, whether such agreement is made expressly or impliedly. Such an undertaking amounts to a waiver of the requirement of presentment, and the law therefore respects the intention and agreement of the parties. 4. Waiver after maturity. Clause C provides that presentment becomes unnecessary where, after maturity and with knowledge of non-presentment, a party makes part payment, promises to pay the amount wholly or partly, or otherwise waives the right to object to non-presentment. I. Part payment. If a party voluntarily makes partial payment after maturity despite knowing that no presentment occurred, he acknowledges liability and cannot later rely on absence of presentment as a defense. 2. Promise to pay. A promise to pay the whole or part of the amount due similarly amounts to recognition of liability and waiver of objections regarding non-presentment. 3. Other waiver of rights. Any conduct clearly indicating that a party does not intend to rely upon non-presentment as a defense may amount to waiver, whether through express statements or conduct inconsistent with denial of liability. For more details, contact us.